Let's start by distinguishing between three sources of healthcare services: Medicare, Medicaid, and Medi-Cal. Medicare is a health insurance program funded by the federal government for people who are 65 or older, certain younger people with disabilities, and people with end-stage renal disease. There are three parts of Medicare. Part A provides hospital insurance. You usually do not pay monthly premiums for Part A if you or a spouse paid Medicare taxes while working. Part B is medical insurance, covering certain services and supplies. Everyone pays a premium for Part B. Part C covers prescription drugs. With a Medicare drug plan, the amount you pay for each drug depends on which plan you choose. There are no limits on assets or income to qualify for Medicare. If you meet the health or age qualifications, you are eligible. Although Medicare recipients may receive Medicaid or Medi-Cal, the programs are not related. While Medicare is a federal program, Medicaid is a joint state and federal program. Each state operates its own Medicaid system. For example, it is called Medi-Cal in California, Medicaid or STAR in Texas, and Mo Health Net in Missouri. The states must follow federal guidelines to receive funding from the federal government, which covers about half the costs. The state pays for the rest. Medicaid helps people pay for their health care. People can use Medicaid to pay for doctor's visits, medicine, disability services, and more. Today, Medicaid is the largest source of health coverage in the United States, providing health care to 1 in 5 Americans. This includes the elderly and people with disabilities, children, pregnant women, and adults who qualify because their assets and income are under certain levels. For the elderly and people with disabilities, Medicaid covers long-term services and supports, including transportation, nursing, and personal care worker services. Still more importantly, Medicaid covers the costs of long-term care, including in nursing homes. Given the high cost of such services, without Medicaid, these costs can quickly deplete someone's entire estate. Unlike Medicare, Medicaid is means-tested. To qualify, you must have limited income and limited assets. For that reason, Medicaid planning often focuses on giving away assets to qualify for Medicaid in anticipation of needing long-term care. As we will see soon, that is no longer necessary in California, although it remains necessary in other states. Medi-Cal is California's Medicaid program. It helps pay for medical care for low-income Californians. Medi-Cal provides health insurance to 1/3 of California's population, including 65% of the residents of California's nursing homes. To receive Medi-Cal, one must pass medical, income, and asset tests. The medical qualifications include the inability to perform key activities and functions of daily living. The income qualifications place a cap on the income of the Medi-Cal recipient, while the asset qualification places a cap on the value of the recipient's countable assets. The asset qualifications for Medi-Cal are undergoing massive changes. Until 2022, having more than $2,000 in assets would disqualify an individual for Medi-Cal. Starting in 2022, that amount was increased to $130,000. It is projected that the asset test will be entirely eliminated in 2024, meaning that an individual could have millions in countable assets and still qualify for Medi-Cal. Countable assets include cash, money in accounts, or a second vehicle. Exempt assets, which do not count against the asset limit, include one's primary residence, one vehicle, and personal household items. While asset limits are changing, income limits are not changing. After January 1st, 2024, financial eligibility for aged and disabled Californians who are enrolled in Medi-Cal will be based solely on the applicant's income. Californians must have household incomes that do not exceed 138% of the federal poverty line. In 2023, that amount is $1,677 for a single adult per month. Unearned income, like interest and dividends, does count as income. An individual whose income exceeds the limits may be eligible for Medi-Cal with a monthly share of cost. For nursing home care, Medi-Cal has no income limit. However, a nursing home resident on Medi-Cal must give all monthly income to the state to offset the costs, except for a personal needs allowance of $35 per month. Asset limits still apply to qualify for supplemental security income. SSI in California can pay a significant amount monthly for an older person or an adult with a disability. The asset limit for SSI remains $2,000 for individuals and $3,000 for married couples. Similarly, Medi-Cal estate recovery rules remain unchanged. The federal government requires California to seek recovery of payments from certain estates, including those of beneficiaries who were 55 or older when they received Medi-Cal benefits for nursing home services. The state can make a claim against your estate for the amount of Medi-Cal benefits paid or for the value of the estate, whichever is less. If a probate is opened for your estate, the state of California will file a claim. There are important exceptions to Medi-Cal estate recovery. First, if the Medi-Cal recipient is survived by a child under age 21 or a disabled child of any age, then the state cannot recover. Similarly, if the Medi-Cal recipient is survived by a spouse or a registered domestic partner, a claim is prohibited and forever barred. States are also required to establish procedures for waiving estate recovery when recovery would cause an undue hardship. California also cannot reach other assets, including property transferred prior to death, which is no longer in the beneficiary's name, life insurance proceeds, and retirement accounts, unless the estate is named as beneficiary or it reverts to the estate. Finally, as mentioned, property not subject to probate cannot be reached by Medi-Cal estate recovery, including property held in trusts. An estate planning attorney like myself can help you to get as many assets as possible into these exempt categories to avoid Medi-Cal recovery. To be clear, assets properly held by a trust are not subject to probate and therefore cannot be subject to Medi-Cal estate recovery. By contrast, assets distributed through a will, depending on the value of the estate, are usually subject to probate in California and therefore reachable through Medi-Cal estate recovery. Do not neglect estate planning now that Medi-Cal asset limits are being removed. Medi-Cal recovery can catch you off guard, but it is entirely avoidable. The key is to be sure all your assets are exempt. I'm Daniel Van Slyke, an estate planning attorney licensed in California, Texas, and Missouri. You can find me at iplanlaw.com.